Well, time yet again proves Arch right, doesn't it? Although, I will admit, I was beginning to doubt the authenticity of my crystal ball with this one right here, as I mean, Palworld came out months and months and months and months ago now, and yet, finally, at long last, Nintendo is launching a lawsuit against Pocket Pair, filing lawsuit for infringement of patent rights, we'll get to that because that is actually rather important, against Pocket Pair Inc. Together with the Pokemon Company, filed a patent infringement lawsuit in the Tokyo District Court against Pocket Pair. This lawsuit seeks an injunction against infringement and compensation for damages on the grounds that Palworld, a game developed and released by the defendant, infringes multiple patent rights. Okie dokie then. This is available in Japanese, it is available on the actual Nintendo website, it is available on their Twitter. This, for all intents and purposes, appears to be a genuine lawsuit launched against Pocket Pair, the developers of Palworld. If this is a hoax, then by God, it is one hell of an elaborate one, which is beginning to rival the scale and scope of what the Israelis pulled on the Palestinians just the other day. But anywho here, you might be wondering, why now? That's a very good question. That is a very goddamn good question. Well, it's probably this. Literally yesterday, or a couple days ago by now, the Pokemon Company won a big copyright lawsuit against several Chinese companies for, well, ripping off their IP, which is kind of what China does. This then becomes an interesting precedence for them to bring to the Japanese courts and say, okay, listen here, we just defended our copyright claim, we won it, it's obvious that these people are infringing upon our intellectual property, so slap them. There's nothing really to discuss here. Though, again, there's an interesting thing here. Let's go back to the page. Patent rights, infringement of patents rights. This is rather important, because you see, if they were filing a copyright lawsuit, oh boy, I think they'd win. Oh boy, I think they would win. I think they would win instantaneously. See, copyright law is a fairly interpretive field where you can never be entirely certain about who's going to come out on top, as it has a lot to do with, are you a competitor in the field? Can a reasonable person mistake your product for the other person's product, etc., etc. Where, how do we put this? Say, for example, if you put Palworld up next to Pokemon, could a reasonable person mistake the two? Yes. Oh, fuck yes. Oh, good god damn yes. No doubt about it. But here's the thing as well. You might also have, say, a company called Whirlpool, right? And their logo is a Whirlpool, nice and simple. And then they look at another company that's also called Whirlpool, and their logo is also a Whirlpool. Well, this is copyright infringement, clearly. They're using our trademark. Let's sue them. Well, not necessarily. If one company is, say, a washing machine company, for example, and the other is a construction machine company that for some reason call itself Whirlpool, I didn't think this example through, then the judge might very easily look, okay, you're not making the same product, you're not competing for the same customer base, you're not damaging each other's brand in any way, and if somebody by some miracle mistook the construction company for the washing machine company, well, worst case scenario is like, ding, hello, I'd like you to clean my clothes, please. Like, we build houses here. No harm, no foul, in essence. And again, oh boy, does Palworld fall afoul of that. Oh, Jesus. Well, actually, sort of, kind of, yes, and sort of, kind of, no. In that Palworld, of course, is a very different video game from a Pokemon game. That it's a survival crafty game with lots of mechanics, like making the pals build stuff, or power generators, or cook food, etc. So, sort of, kind of, and yet not really necessarily. That's where the interpretive parts come in. But a patent infringement lawsuit. Half of me wonders if the Japanese text is simply being mangled in the English translation or something, but this is their official English release. This isn't translated, like, you know, with Google, like, make it into English thingy, right? This here is their actual English release, so unless they manage to screw it up by passing it through Babelfish or something, Again, patent infringement, same there as well. It would be weird, because, isn't it? A copyright is you saying like, hey, here's my thing, here's my Pikachu, right? My Pikachu looks like this is my brand of Pikachus and Pokemons, and if something looks too much like this, I am going to allege that they're infringing on my copyright, which, again, Palworld 2, let's be entirely honest here, definitely, absolutely, certainly does. By any reasonable interpretation. Okay, fair enough. Let's, ameliorate ourselves here. It flies dangerously close to the sun, let's put it like that instead. It draws perhaps a pinch too much, but perhaps too vivid inspiration from Pokemon, shall we say. But a patent lawsuit... I actually am not entirely sure if Pokemon is a patent, because a patent, of course, is something granted by the government. It's usually something for something physical, like, for example, my family's company's tool changer has a patent because we invented a specific way to lock the tool changer so as it, mates with the tool part. We have patented that. Or a patent might be of a type of bicycle lock, of something that you can identifiably go like, okay, this and that, this is my patent, nobody can make anything similar to this patent. But, I mean, in the case of a video game, they would have to be patenting mechanics, I suppose? You can sort of kind of patent a creative work, but now this is going to take place in Japanese court as well, mind you, which is going to further complicate things, because in a Western court, I believe this would already have failed because the statute of limitation has already run out. See, one of the things that companies actually have a duty to do is maintain their copyright, or patent in essence, where if you do not actually challenge somebody using your copyright, then you will actually stand to lose your copyright after a period where it would reasonably be expected that you would learn of the infringement. And considering the enormous sales success of Palworld, like what, 7 or 8 months ago? I'm pretty sure it's 6 months in the US, right, for that stuff, and Nintendo is going to have a very hard time arguing that they weren't aware of Palworld before that time. So, again, a patent lawsuit, though. I kind of wish I actually read Moonrune so I could look up the lawsuit itself, where they will have to actually have detailed what patents they're asking for, as they also mention multiple patent violations, so it's not just one. I would also frankly expect there to be a copyright lawsuit following up on this in the fairly near future. If anything, I almost feel like this might simply just be Nintendo loading up a shotgun the size of their legal team and firing at Pocket Pair in the hopes of simply overwhelming them. Now, Pocket Pair must have known that this was a possibility. Again, you made a video game that looks like this. Surely you would have been looking over at Nintendo thinking, yeah, we should probably have some lawyers on retainer for this. I even remember, I think it was the Palworld CEO or creative director or something, mentioned that they had been in contact with legal experts and that the game had passed legal review. Which I doubt, mind you, but so that they have at least thought about this, that this could be a potential consequence of their actions, right? And again, oh yes, it could be. So they must have some war plan here, and considering their enormous sales, even though the game did fall off drastically thereafter, and they haven't, as far as I'm aware, introduced any further monetization strategies, their war chest should nevertheless be pretty goddamn hefty at this point, to the point where they could potentially even contend with the Nintendo's army of lawyers, which might incidentally be why Nintendo is trying the buckshot approach of simply accusing Palworld of anything and everything at the same time in order to lessen their resources, because in a war of attrition, Nintendo will win by quite the landslide as well. No doubt that's one of the problems with our current year legal system, frankly. But, It's a strange approach. It's a very, very weird approach. Perhaps it even has something to do with the statute of limitation. That's not technically the term, I think, but I've forgotten the actual legalistic term for this. That maybe the patent one has a longer period than the copyright one, I would imagine, perhaps. Again, I'm hardly a Japanese legal scholar by any stretch of the imagination, so take anything I say here with a metric assload of salt, but anywho, the fact of the matter is Nintendo is suing Pocket Pair. Better late than never, I do suppose, and they are going to have to ask a lot of tough questions. See, I'm pretty sure Nintendo probably has this one in the bag, but Pocket Pair does have some defenses in terms of the fact that it's a very different kind of video game, focused around very different mechanics, and targeting a very different crowd than a traditional Pokemon game. And Nintendo is then going to have to argue how this game's mechanics, I would presume, as... Can you even patent game mechanics? Who knows? Japan, right? How that violates their patents as well. It's gonna be an interesting one, which I would bet on Nintendo in. And if Nintendo wins, nothing will change, but if Palworld wins, mind you, ooh, that could open the door to a whole wide variety of, legally distinct alternatives. Marines in space, guardsmen of the Imperium, non-female custodies of terror. And you know what? That would be no bad thing. As much as I think Nintendo is going to win this, I kinda hope they lose as well. I really do. It would be funny. It would be tremendously funny. And it would do interesting things to the patent/copyright law system, at least in Japan, as this, again, in America would probably be a far more of a long shot. Anywho, do let me know what you think in the comment section down below, and until next time, I have been Arch. Thank you very much for watching, and I do hope to see you all again soon. Till then, have a good day.